Hello, class. So we are going to discuss the remedies available to the seller and the buyer when there is a breach of the contract of sale involving an immovable or real properties. For the seller, guys, the typical breach of the contract will be failure of the buyer to pay the price, including absconding with the immovable or disposing it to a third person without first paying the purchase price. So the remedies available to the seller will be specific performance if the seller still believes that the buyer has the capacity to pay. Okay. Otherwise, the seller will have no choice but to ultimately rescind the contract of sale in order to recover the immovable if there has been previous delivery of the property. So under the Civil Code, there are actually two kinds of rescission. First, we find rescission under Article 1191, wherein if there is substantial breach by any of the parties of the performance of their obligation, then the contract can be rescinded. And that kind of rescission is properly called resolution. There is another kind of rescission found in the Civil Code. And if you remember, under the law on obligations and contracts, it enumerates the kinds of rescissible contracts. But that kind of rescission, guys, it is grounded on lesion and will distinguish the difference between the two in later slides. There is also a special kind of rescission found in Article 1592. And there's equitable resolution in Article 1234, guys. That's 1234, huh? Not 1592. And then in cases when the seller will have reasonable fear of loss of the immovable property, meaning that it is about to be sold to another, and that there is fear of loss of the price, then that is a situation called an anticipated breach. And under Article 1591, the seller can also rescind the contract. So what is resolution as described in Article 1191? So resolution, guys, this is a remedy available when there is a breach of reciprocal contracts. When one of the parties is not able to perform their obligation simultaneously with the other party who is the injured party and has the right to rescind the contract. So when there is substantial breach of the contract, guys, the injured party can choose between fulfillment and the rescission of the obligation. And of course, will be entitled to damages as well. There can also be rescission if even after fulfillment or the filing of an action for specific performance, the performance of the obligation still is impossible or has become impossible. And in that case, a judicial decree of rescission may be obtained by filing a petition in court. So the Civil Code also refers to rescissible contracts under Article 1381. So do you remember this? Wherein if the ward will suffer any lesion from a contract entered into by the guardian. The same case with absentees when there is lesion in a contract entered into by their representative. So those contracts in fraud of creditors, and it becomes impossible for the creditor to demand satisfaction of the debt. And there's also lesion, guys, when things under litigation are disposed by the defendant without knowledge and approval of the litigants and the court. So In this kind of contract, guys, this can be rescinded on the ground of lesion, meaning alcance. So, in the case of award, if there is lesion by more than 1/4 of the value of the things which were sold, then it is a ground for rescission. Unlike in Article 1191, guys, wherein the ground to invoke this remedy of rescission or resolution is substantial breach of the contract. The only ground that can be used when you are rescinding under Article 1381 will be those enumerated in that article. Okay, when there is lesion. So illustrative case will be the case of spouses Canoe versus spouses Galang. So in this case, the spouses Galang own a house and lot and they mortgage the property with NHMFC and Surf Realty. While under the mortgage, the spouses Canoe agreed to buy the property for 120,000 and assume the balance of the mortgage. So they executed a deed of sale with assumption of mortgage obligation, with the purchase price being 250,000. So the spouses Canoe was able to take possession of the house and lot, and they were able to make payments with the mortgagee. However, the assumption of mortgage was later disapproved. So they ended up stopping payments to the mortgagee. And also, the spouses Canoe was only able to pay 75,000 pesos to the spouses Galang, even though the purchase price was for 250,000. So the spouses Galang resumed paying the remaining mortgage loan with NHMFC. So after payment of the mortgage loan, the spouses Galang sought the release of the title, but the spouses Canoe opposed, contending that the property was already theirs. So bagag na ang spouses Canoe, guys. Spouses Canoe then filed a complaint for specific performance against the spouses Galang, invoking that deed of sale with assumption of mortgage obligation. So the spouses Galang counterclaimed that the failure to pay the full purchase price and to update the monthly amortizations gives rise to rescission of that deed of sale with assumption of mortgage. So the regional trial court decreed rescission, but on appeal, the spouses Canoe argued that there was no substantial breach and that their action for rescission is only subsidiary. So the spouses Canoe also sought additional time to perform or complete their obligation under the deed of sale with assumption of mortgage. So how did the court resolve the arguments raised by the spouses Canoe on appeal? Particularly the issue on rescission being a subsidiary remedy and not a principal remedy. So the Supreme Court here held that there was substantial breach. So Article 1191, which refers to the remedy of rescission, or more accurately, resolution, is predicated on a breach of faith by the other party that violates the reciprocity between them. So rescission is not allowed for slight or casual breach. It is only for such breaches that are substantial and fundamental as to defeat the object of the parties in making the agreement. So the question of whether a breach of contract is substantial depends upon the attending circumstances and not merely on the percentage of the amount not paid. So petitioner's failure to pay the remaining balance of 45,000 is substantial breach. So taken with the fact that the last payment made was in 1991 or 18 months before the spouses Galang paid the outstanding loan of the mortgage loan, then there was intent on the part of the spouses Canoe to renege on their obligation. So they were not religious in paying the amortizations with the mortgagee. As admitted by them, in the span of 3 years, from 1990 to 1993, their payments covered only 30 months. So that constitutes another violation of the deed of sale with assumption of mortgage. On top of this, there was no formal assumption of mortgage because it was disapproved, remember? It was, in fact, not approved because the spouses Canoe failed to submit requirements in order to be considered as assignees or successors in interest over the property. So the court here clarified that rescission under Article 1191 is not subsidiary. So the rescission on account of breach of stipulations is not predicated on injury or economic interest of the party, but on the breach of faith by the defendant that violates the reciprocity between the parties. So it is not a subsidiary action, unlike Article 1381. So rescission is a principal action retaliatory in character, it being unjust that a party be held bound to fulfill his promises when the other violates his. So unlike rescission by reason of lesion or economic prejudice, the cause of action is subordinated to the existence of that prejudice because it's raison d'etre as well as the measure of the right to rescind. So you do not apply the ground of breach, the ground of economic prejudice or lesion to cases not otherwise enumerated in Article 1381. Okay, so another kind of rescission which is provided for as a remedy in the Civil Code is that found in Article 1592. So take a look at this, at the text of this article, guys. That in the sale of immovable property, even though it is stipulated that failure to pay the price at the time agreed upon, that rescission of the contract shall of right take place. The vendee may pay even after the expiration of the period, as long as no demand for rescission of the contract has been made upon him either judicially or by notarial act. After the demand, the court may not grant the vendee a new term. So this article, guys, it is not applicable to contracts to sell, only to absolute sale of immovable property. So what's the remedy here that's available to the seller? So there can be judicial rescission and there can be rescission by notarial act. So meaning the seller can execute a deed of rescission, okay, and then give notice to the other party that the contract is being rescinded. So illustrative case will be the case of Valarao versus Court of Appeals. So what happened in this case? The spouses Valarao sold to Meden Arellano a parcel of land under a deed of conditional sale. So the deed provides expressly that the rescission of the contract shall of right take place upon failure of the vendee to pay 3 successive monthly installments. So it turns out that the vendee indeed failed to pay 3 monthly installments. And when the vendee was ready to pay, the vendor already refused to accept the payments. The vendee filed a petition for consignation, but the vendor sent a notice of automatic rescission. And in the vendor's answer to the petition for consignation, the vendor invoked the automatic rescission clause and demanded that the property be vacated and returned. So the regional trial court here decreed rescission and ruled that the purchase price partially paid by the vendee be forfeited as rentals, and also ordered payment of liquidated damages in accordance with the contract. So on appeal, the Court of Appeals reversed the decision of the RTC, applying Article 1592. So the Court of Appeals held that the notice of automatic rescission was not notarized. And also, the court found that the failure of the vendee to pay the monthly installments within the stipulated time is rather slight and not substantial. And that to authorize the automatic rescission will work injustice to the vendee because the vendee has already paid a total of 2.028 million out of a total obligation of 3.225 million. So issue that had to be resolved and elevated to the Supreme Court. Is the Court of Appeals correct in applying Article 1592 to a deed of conditional sale? So the Supreme Court held, guys, that no. Article 1592 only applies to a contract of sale and not to sale on installment or to a contract to sell. So as early as the case of Luzon Brokerage versus Maritime Building, the court already held that Article 1592 requiring demand by suit or notarial act in case the vendor of realty wants to rescind does not apply to a contract to sell or promise to sell, where title remains with the vendor until full payment of the price. So the deed of conditional sale executed by the parties is of the same nature as a sale on installment or a contract to sell, which is not covered by Article 1592. So take note of the application of 1592 regarding rescission by notarial act. So the prescriptive period for bringing an action for rescission under both Article 1191 and 1592 is that found in Article 1144, which provides that the action upon a written contract should be brought within 10 years from the time the cause of action accrues. Okay, the third kind of rescission available to the seller in the Civil Code is that found in Article 1234, or equitable resolution. So this is illustrated in the case of Legarda Hermanos versus Saldana, wherein the buyer sought to purchase 2 small residential lots on installment for 10 years. So the buyer was able to pay continuously for 8 years on the principal alone. And his total payment exceeded the value of 1 lot. Because remember, he purchased 2 parcels or 2 lots. So in the resolution of this case, guys, the court upheld the conveyance of the property, one of the lots, to the buyer, which is considered as fully paid already. Because in that particular case, guys, the payments made by the buyer did not specify any application, whether it went towards payment of the first lot or to the second lot. So to justify the ruling, guys, the Supreme Court applied as legal basis Article 1234, wherein if the obligation has been substantially performed in good faith, the obligor may recover as though there had been strict and complete fulfillment, less damages suffered by the obligee. And that in the interest of justice and equity, then the decision can be upheld under Article 1234. So muna ako mga favorite na provision, guys. Article 1234, when all else fails ba.
So, naagi tayo makita nga remedy under the civil code so that we can fight for the cause of our clients. Hindot kayo siya, no? 1234. Sabi ni mo matiway ka, pero makuha din ni mo ang usa ka lot. So, let's move on to the remedies available to the buyer when there is a breach of a contract of sale of immovable. So, when the buyer becomes unable to pay the purchase price, then the remedy available will be rescission, wherein pwede ma-restitute ang payments back to the buyer. And there can be the remedy found in Article 1592, wherein before the judicial rescission or before the notarial act of rescission is made by the seller, then the buyer can go ahead and pay whatever was unpaid. There are also remedies found in the Maceda Law or the Realty Installment Buyer Act, and remedies as well in Presidential Decree 957 or the Subdivision and Condominium Buyers Protective Decree. Also, if there is anticipated breach, there's a remedy found also in Article 1591 and also Article 1191 to cover all other possible grounds of breach of contract on the part of the seller. So let's study this Maceda Law or the Realty Installment Buyer Protection Act, because just like the Recto Law, it is also a popular topic that is asked in the bar exams. So when is the Maceda Law applicable? So 3 requisites to apply the Maceda Law. First, you have to identify whether the transaction or contract involves sale or financing of real estate. Second, the mode of payment, guys. It must be payable on installment, not a straight sale. And third, the purchase of the property must be for residential use. And this includes even condominium apartments. So excluded from the coverage of the Maceda Law are industrial lots, commercial lots, and sale of lots to tenants under Republic Act 3844. Para mga carp-carp. So here's a summary of the rights of buyers of real property in installment. So we need to establish whether the buyer here has paid at least 2 years of installment. So 2 or more years of payment. And or if the buyer paid less than 2 years. So if the buyer has already paid at least 2 years of installment, then here are the rights of that buyer who is already unable to proceed with the contract to sell. So the buyer is granted 1 month grace period for every 1 year installment payments made. Okay, and there's no additional interest that can be charged. But this grace period, guys, this can be used only once every 5 years. The buyer also has the following rights in case there is cancellation of the contract. So there is a refund of the cash surrender value. And the cash surrender value is composed of 50% of the total payments made. And after 5 years of installments, an additional 5% every year, but not to exceed 90% of total payments made. So the 10% of the payments made will be forfeited to the seller for use of the property while the contract was in existence. Another right of the buyer is that after cancellation, the actual cancellation of the contract will take place only after 30 days from receipt of the notice of cancellation or demand for rescission by notarial act, and full payment of the cash surrender value. So if the seller here will not refund the cash surrender value, even if ni-serve na siya notice of rescission or demand na siya og rescission by notarial act, then there is no cancellation that can take place. Kay end man, those two actions must be performed by the seller in order for there to be a valid cancellation. Another right of the buyer is that he or she can sell or assign the contract and reinstate the contract by updating the account during the grace period and before actual cancellation. Another right of the buyer is that the buyer can pay in advance without interest. Because when you purchase real property in installment, guys, na siya schedule of payments, and you'll see a breakdown of the application of your payment. Kanang muadto sa interest ug muadto sa principal. So if you want to make advance payment, then as long as the interest are first paid off, then you can prepay the contract so that mahuman nimo siya dayon, and that can be made without interest. So are there rights available to the buyer who has paid less than 2 years? Naasad siya, right? Nagod sa table, no? So the grace period for a buyer who has made less than 2 years of payments is 60 days grace period counted from the due date of the payment. And in case of actual cancellation, then it will take place after 30 days of receipt of notice of cancellation or demand for rescission by notarial act. So the same sad siya with buyers who paid for 2 years or more. Pwede gud siya ma-sell or assign the contract or reinstate the contract by updating the account before actual cancellation. So ang wala lang yun ni buyer who has paid less than 2 years of installments is the refund of the cash surrender value. So TY jud ka, guys. The payments you made are forfeited to the seller, and it serves as rental nila while you occupied or used the property. So if you are making monthly payments for real property in installment, make sure nga imo nang i-occupy dayon ang premises, kay at least ma-enjoy nimo ba while wala pa ka naka-abot o 2 years sa imong pagbayad. So remember this, these are the requisites for valid rescission or cancellation under Section 4 of the Maceda Law when the buyer has made less than 2 years of installment payments. So 60-day grace period, reckon from the date the installment became due. Second, the seller must give the buyer a notice of cancellation or demand for rescission by notarial act at the expiration of the grace period. And third, the seller may actually cancel the contract only after 30 days from the receipt of that notice or demand. And as a fourth requisite for a valid cancellation, in case the buyer has made more than 2 years or more installment payments, then the fourth requisite would be payment of the cash surrender value. So before actual cancellation, guys, the buyer can always sell, assign, or reinstate the contract. So kung na yung mga advice ninyo, okay, mo man siya predominant karon na means of purchasing property, mag-sale in installment. So you can already give them this advice. Paabton jud og 2 years. Mas maayo paabton og 2 years. So illustrative case is the case of Orbe versus Philinvest land. So what happened in this case? So in this case, guys, Orbe entered into a purchase agreement with Philinvest for the total contract price of 2.5 million payable on installment. So Orbe from June 17, 2001 to July 14, 2004 was able to pay a total of 608,648 pesos and was unable to make further payments on account of financial difficulties. So on October 4, 2004, Philinvest sent a notice of cancellation with a URAT, which was received by Orbe on October 18, 2004. Orbe sought reconsideration of the cancellation, but the parcel of land was already sold by Philinvest to another buyer. So Orbe filed a complaint against Philinvest for refund with damages before the HLURB field office. The HLURB ruled in favor of Orbe and held that since he made payments for a period of more than 2 years, then all of which should be credited to the principal. And Orbe was entitled to a cash surrender value refund equivalent to 50% of the total payments made pursuant to Section 3 of the Maceda Law. Philinvest appealed, and the commissioners ruled that Orbe's payment fell 2 months short of the equivalent of 2 years installment. But equity should come in, especially whereas here the payment period is relatively short and the monthly installment is relatively of substantial amounts. Thus, Orbe was still found to be entitled to a 50% refund. So Philinvest further appealed the decision of the HLURB commissioners to the Office of the President. And the Office of the President adopted the findings of the HLURB that the payments made were more than 2 years already. So Philinvest still further appealed the case and now to the Court of Appeals. They argued that the Maceda Law requires for refund of the cash surrender value is not the length of time of at least 2 years from the first payment to the last payment, but the number of installments. So dapat daw na ay 24 monthly installments made. So issue, how does 2 years of payment by length of time be computed? Is it by length of time or by amount paid? So dapat 2 years good, 24 months, or 24 monthly installments. And second issue, is the notice of cancellation with the URAT a valid notarial cancellation? So the ruling in this case is that the phrase at least 2 years of installments refers to value and time. It does not only refer to the period when the buyer has been making payments, with total disregard for the value that the buyer has actually conveyed. It refers to the proportionate value of the installments made, as well as payments having been made for at least 2 years. So when Maceda Law speaks of paying at least 2 years of installments, in order to benefit under this section, it refers to buyer's payment of 2 years worth of the stipulated fractional periodic payments due to the seller.
When the buyer's payments fall short of the equivalent 2 years worth of installments, then the benefits are limited only to a buyer who has paid less than 2 years installment. And should there be failure still of the buyer to make the payment within the grace period, then the seller can cancel the contract. But any such cancellation is ineffectual unless it is made through a valid notarial act. So, what is a valid notarial act, guys, for purposes of canceling a contract of sale of real property in installment? So, required DI na it should be an acknowledgement and not URAT. Court here said that if acknowledgement is necessary in the customary rendition of public documents, with greater reason should an acknowledgement be imperative in notices of cancellation or demands for rescission made under Section 3 and 4 of the Maceda Law. So in case that the seller is a juridical person, and juridical persons only act through their representatives. In these cases though, guys, it is imperative that the officer signing for the seller indicate that he or she is duly authorized to effect the cancellation of an otherwise perfected contract, and not simply just any personnel. So individuals signing the notice of cancellation or demand for rescission must demonstrate their specific authority. And this is through a board resolution or by stipulations in the articles of incorporation or bylaws naming that particular officer as authorized to sign such documents. So what happens when the cancellation is declared invalid, but the property is already sold to another? So in that case, guys, two options. There can be a refund or an offer to substitute properties. And it is exclusive to the buyer to choose between these two options. And in case of refund, the buyer is entitled to a refund of the actual value of the lot resold, provided that the buyer has already fully paid the principal. But if the buyer only made partial payments, the refund shall only be the amount actually paid by Orbe or to Philinvest to prevent unjust enrichment. So remember that Orbe case, guys. Pang bar question kay siya. Okay, another special law which grants rights to buyers of real property is Presidential Decree 957 or the Subdivision and Condominium Buyers Protective Decree. So coverage of this law is the purchase of subdivisions and condominium, subdivisions, house and lot na, and condominiums. So salient features of the law is that sellers of these properties are required to have registration and be licensed to sell. And there can be no forfeiture of payments. There are rules on the mortgage of the housing project, the subdivision project. And there are rules on advertising. So we'll go over the salient features one by one. So developers, guys, of subdivisions and condominiums are required to secure development permit, registration certificate, and license to sell from the HLURB, which is now the Department of Human Settlements and Urban Development. So the sale of subdivision or condominium project includes offering to sell, advertising to sell, and receiving reservation deposits. So mga preparatory transactions
to entering into a sale of subdivision project or condominium project covered by this special law. And take note, guys, that even though there is non-registration or unlicensed developer, it will not automatically render the contract of sale void. So this presidential decree, guys, it prohibits the forfeiture of installment payments made by the buyer. When the buyer is not delinquent and the buyer only suspended payments because of the failure of the developer to complete the development within the required period. So in this instance, the buyer can choose between being reimbursed of the total amount paid, including amortization interest, with interest pa gyud at the legal rate, or demand completion of the development project. So the rights of the buyer in the event of failure to pay the installments due will be governed by the Maceda Law. So if the failure to pay is based on reasons other than failure of the owner developer to develop the project. So in this kind of transaction, guys, in this kind of sale, wherein the seller developer will actually enter into a contract to sell with the prospective na buyer. So the seller developer owner retains ownership of the property and can mortgage it. Okay, but PD 957 provides for this rule that there can be no mortgage of any lot of a development project without permit to mortgage from the HLURB. So if there is approval of a mortgage by the HLURB, then the buyer has the option of paying installments directly to the mortgagee. And the seller is also obligated to redeem the mortgage without any cost to the buyer within 6 months from issuance of the title to the buyer. And the buyer here remains to have the right to receive a clean title without any mortgage or encumbrance. This rights, guys, this can be demanded upon full payment of the purchase price. Okay, that's the time when the buyer can demand execution of a deed of sale and issuance of a title already in the buyer's name. So if the seller developer owner will advertise the construction of common facilities and other infrastructures in advertisements, whether it be kanang television or radio ad or brochures or leaflets or other public announcements, then those representations are deemed part of the main contract and is enforceable against the developer. So the seller developer will submit a subdivision plan for the project, and if any alteration is made in the approved plan relating to roads, open spaces, facilities, and other forms of development, will require prior approval from the LGU and the written consent of the homeowners association. So payment of taxes. The realty tax will be paid by the developer without recourse or without right to reimbursement from the buyer for as long as the title has not yet passed to the buyer. However, if the buyer has already taken possession of the lot, although the title is not yet transferred, then it will be the buyer who will pay the realty tax, effective the year following the taking of possession. So no other fees are allowed for any community benefit. So fees to finance services for common comfort, security, and sanitation may be collected only by a properly organized homeowners association and only with the consent of a majority of the lot or unit buyers actually residing in the subdivision or condominium project. So as to right of way, when the project will have no access to any existing public road, the developer is required to secure a right of way. And it must be developed and maintained according to the requirement of government authorities. And if the seller will fail to provide a right of way, then the buyer can demand proportionate reduction in the purchase price. So Presidential Decree 957, guys, prohibits any waiver. So any condition, stipulation, or provision in the contract of sale whereby the buyer or any person will have to waive compliance with any provision of PD 957 is considered as void. So there's another special law, guys, the Condominium Act or Republic Act 4726. So it specifically provides for the ownership rights and obligations of condominium owners. So take note that Filipino citizens can own condominiums and also foreigners, but they are restricted to owning no more than 40% of the total and outstanding capital stock of a corporation. So corporation ra, guys, they can acquire units. Okay, the unit raman, it's not the land that is being sold. So condominium corporations are typically formed to manage common areas and assets of the condominium. So the unit owners shall automatically be members or shareholders to the extent of their interest. So if you are no longer a unit owner, then you will automatically lose membership and you are no longer a stockholder of the condominium corporation. So each condominium owner has the exclusive right to mortgage, pledge, or encumber the condominium unit. So what are the rights of a condominium unit owner? Absolute ownership of the unit, co-ownership of land and common areas, exclusive easement of the space of the unit, and then easement but non-exclusive of the common areas for ingress or egress. The unit owner has the right to sell, lease, or mortgage the unit, and the right to participate and vote in condominium corporation meetings. So nasa obligation si condominium owner. Pay the tax, share the realty tax on the land and common areas, pay the insurance, share the insurance in the common areas, comply with use restrictions, pay dues and assessments, and give other unit owners right of first refusal if so required by the master deed. Pwede dahil mag-right of first refusal. So can a condominium corporation sell the condominium without consent of the unit owners? So generally, yes. The master deed contains a requirement that the property should first be offered to the other condominium owners within a reasonable time before offering it to third parties. So the common areas, guys, it cannot be sold, exchanged, leased, or otherwise disposed without the approval of the majority of the registered owners and approval of the HLURB. So illustrative case is Lim versus Moldex land. So what happened in this case? So Lim is a unit owner at the Golden Empire Tower condominium project of Moldex land. And CondoCor, a non-stock, non-profit corporation, is the registered condominium corporation. So Lim, being a unit owner, is automatically a member of CondoCor. So Lim protested the election of several persons as officers of CondoCor because they were non-unit owners. And Lim also argued that Moldex, the developer, cannot be a member of CondoCor. She insisted that a condominium corporation is an association of homeowners for the purpose of managing the condo project, and it must be composed of actual unit buyers or residents of the condominium project. So Lim filed a protest before the regional trial court. So is Lim correct? So Lim is not correct. No. So Lim's reliance on PD 957 is misplaced. There is no provision in Presidential Decree 957 which states that an owner-developer of a condominium project cannot be a member of a condominium corporation. Section 30 of PD 957 determines the purposes of homeowners association to promote and protect the mutual interest of the buyers and residents and to assist in their community development. A condominium corporation, however, is not just a management body of the condominium project. It also holds title to the common areas, including the land or the pertinent interest in such areas. Hence, it is especially governed by the Condominium Act. Clearly, a homeowners association is different from a condominium corporation. PD 957 does not regulate condominium corporations and thus cannot be applied in this case. So the Condominium Act does not provide a specific mode of acquiring ownership. Thus, whether one becomes an owner of a condominium unit by virtue of sale or donation is of no moment. It is erroneous to argue that the ownership must result from a sale transaction between the owner-developer and the purchaser. Such interpretation would mean that persons who inherited a unit or have been donated one and properly transfer title in their names cannot become members of the condominium corporation. So let's discuss now cancellation of judicial sales, kaning mga forced sales. How do we cancel this kind of forced sale? So being a sale, a kind of sale, judicial sales are also governed by the general principles of the law on sales. And judicial sales which are voided or made ineffective without fault of the buyer entitles the buyer to the return of the purchase price with interest, okay, and reimbursement of expenses. So as a general rule, the judicial sale can only be set aside upon return to the buyer of the purchase price and reimbursement. So the buyer in a judicial sale, which is a public auction, will have a lien on the property. And that's pursuant to the case of Seven Brothers Shipping versus Court of Appeals. So remember guys, rescission of sale. We have articles 1191, 1381, and 1592. Remember the difference between resolution and rescission. In 1381, the action is only subsidiary and limited to the ground of lesion or economic prejudice, or those cases enumerated in Article 1381. In Articles 1191 and 1592, the rescission is a principal action which seeks resolution or cancellation of the contract. The applicable prescriptive period is 10 years from the date that the cause of action accrues. While in rescission under Article 1381, the action must be commenced within 4 years. So remember guys that the general rule is that rescission is essentially judicial. The exception will be the right to extrajudicial rescission in reciprocal contracts. So the right to rescind is not absolute, even if there is extrajudicial rescission, because the court can still fix the period for compliance of the obligation, except in sale of immovables pursuant to Article 1592. So that concludes our discussion on remedies available to parties when there is a breach of a contract of sale involving movables or personal properties and immovables or real properties. So I'll see you on the next lecture video, guys.